Hi there, I'm attorney Caprice Collins, and I'm delighted to have the opportunity today to walk you through the details of the comprehensive estate plan we created just for you. But before we get started, I want to take a moment to congratulate you. Today is the culmination of a long process. We know you've spent a lot of time thinking how you would like your affairs handled if anything would happen to you. At the same time, here at the Collins Law Group, our team conducted a detailed review of your situation and considered all of your planning options. As we assembled your plan, your documents went through a multiple draft process in our office, and finally, based on our discussions and all the information you provided, we prepared the final documents you'll be signing today. The purpose of this video is to walk you through those final documents and give you a general overview of how your plan will work. To make it a little more interesting, we've included some visual aids to bring this dry legal language to life. Now you might be asking, why is the law firm using a video to explain my plan rather than a face-to-face meeting with the law firm staff? That's a fair question, so let me explain why this process is so much better for our clients than the way we used to do it. For years, we sat with our clients and carefully went through these documents in a long face-to-face meeting. But what we found was that most of our clients quickly forgot the details. In fact, when they tried to explain to family members, sometimes years later, they just couldn't remember how everything fit together. So we asked our clients, what would be the best way to convey all this important information to you? And how could we provide a thorough education for the people responsible for carrying out the plan? They uniformly felt that having their own personal customized video was the ideal solution. So we took the time to restructure how we handle this final signing meeting. Today, we'll give you an opportunity to learn by video how your plan works and to be able to ask questions of our staff if anything was confusing. We've taken great care in creating this video just for you, but if there's any conflict between it and your estate planning documents, your formal documents will always prevail. When the meeting is over, you'll be able to take home a copy of your own customized video. It will always be available if you just need a refresher course or if you want others to know exactly how your plan works. And most importantly, it will be available for your loved ones to help them understand how the planning you've put in place will protect them after you're gone. To make it simple, we've broken this session down into 3 parts. In part 1, you'll follow along as we walk through your legacy wealth planning portfolio. In the beginning, we'll go through the documents in a general way, giving you an overview of how this type of plan works. Don't worry if we discuss things that don't apply to you or your situation. We just want you to get an overall understanding of the scope of the planning and the various options available. Consider this as a mini estate planning education. After we go over the general provisions, we'll focus on the specific options you've chosen and how your individual plan was created. So in this video, we'll first do a general overview and then have a discussion of your specific plan. Now, as we go through your material, you might have a question or two, and that's understandable. If that happens, just grab the legal pad on the table beside you and jot those questions down. Once the video is over, we'll move into part 2. This is where a member of our staff will come in with your actual documents and sit with you as the documents are signed, witnessed, and notarized according to state law, and of course, answer any questions you have. Once everything is properly executed, we move to part 3 of our meeting. Our staff will leave the room and take the signed documents to make copies for you, assemble your legacy wealth planning portfolio binder, and finally create the custom video just for you to take home. Okay, are you ready to get started? I'll be back just a little later in this video tour of your estate plan, but right now I'd like to turn over a portion of the document review to one of my colleagues.
Hi there, I'm Robert Armstrong. And we're going to use this video to go through the Legacy Wealth Planning Portfolio Binder on the desk in front of you. Now, don't worry about trying to follow along in your copy of the paperwork. Instead, just sit back and listen and make notes of any questions that come up. Clients have told us that this is by far the best way to absorb the information. If you need to turn to a specific section of the binder, I'll be sure to let you know. Go ahead and open the binder. It contains a complete copy of all your unsigned legal documents. Now, as you can see, there are many pages of documents inside. But don't worry. We've organized everything for you and broken it down into understandable sections. Each section is separated by a divider tab. That way you can always find the documents you need. Now, the documents in this binder are just copies for your reference. Once you've signed the originals, we'll give them to you in a separate package. It's important to take special care of the originals and keep them in a safe place, like a fireproof safe or a fireproof filing cabinet in your home. If at all possible, avoid keeping your original documents in a bank safe deposit box because banks may be closed when you need them, making it difficult to get access to your papers. So if you're ready, let's get started and take that general overview tour of your Legacy Wealth Planning portfolio. The first tab is the table of contents displaying all the components of your portfolio for easy reference. The next tab is called Trust Information. It contains a summary of key information about your customized documents. We'll return a little later to this section and go over it in more detail. The next tab contains the most important document in your plan, your Family Wealth Trust. It's broken down into multiple articles that cover all aspects of your trust. You can think of each article like a chapter in a book, and once we look at each article individually, it will be easy to understand. The Trust Table of Contents lists all the articles and briefly describes the purpose of each. Let's briefly review the articles together. Article 1, Creation of My Trust. Article 1 simply states that by executing your trust agreement on a certain date, you've created a family wealth trust. You are the trustor, the party who created the trust. There are two names for your trust: the short form name, which merely consists of the name you've chosen for the trust, plus the date it was signed. The formal name of your trust is used for official purposes, like taking title to assets that are either new assets purchased in the name of the trust or existing assets transferred into the trust. Article 1 also identifies your Family Wealth Trust as a grantor trust, which means for income tax purposes, your Family Wealth Trust will use your Social Security number, and all income and losses from assets in the trust are reported on your personal income tax return. And finally, Article 1 identifies your family. The names and birth dates of children are listed here, and additional children born or adopted in the future are included by reference. Now that's it for Article 1. See? We told you it would be simple. Let's now turn to Article 2, Trust Property. Here we identify what property will be owned by the trust and how assets are transferred into the trust. This process is called trust funding. Assets transferred to your Family Wealth Trust will be listed on Schedule A. This schedule acts as an inventory of trust assets. It's important to know that any assets transferred to your Family Wealth Trust retain the same character they had before the transfer. If you revoke the trust sometime in the future, the assets will come out of your Family Wealth Trust exactly as they went in. It is especially important to remember that your Family Wealth Trust will only control the assets actually transferred to the name of the trust. In short, all assets you own now, as well as assets acquired in the future, should clearly show your Family Wealth Trust as the owner. Now, there are some exceptions to this requirement, and we'll explain that when we start the funding process. Now let's turn to Article 3, Trustees. This is where we designate the initial or current trustees in charge of managing your trust asset. Now, most likely you named yourself as initial trustee, so that means you are both the trustor and the trustee of your family wealth trust. Trustor means you created the trust and funded it with your assets. You're the owner. Trustee means that you're responsible for managing and protecting the trust and its assets on behalf of the beneficiaries. We also name the people or institutions you've picked to act as your successor trustees. These are the people who will carry out your instructions and manage the assets in the future. They will begin to serve only after all of the initial trustees are deceased, resign, or become unable to manage their financial affairs. We've included a final provision in Article 3 for the appointment of the special co-trustee, known as the trust protector, who is very important to the operation of your family wealth trust. The trust protector has many important functions, which we've summarized for you in a special client memorandum entitled Special Co-Trustee or Trust Protector Provisions. You can find this in your portfolio near the back in a tab called Other Documents. Article 4, Lifetime Rights of Trustor, describes how your family wealth trust works while you are alive. In other words, what can you do with the assets in the trust from now until the time of your death? Well, the answer is very simple. Anything you want. There are no restrictions on your rights to manage the property, and there are no restrictions on your rights to spend or dispose of a part or all of the assets in the trust. While you're alive and well, you can amend or revoke the trust at any time. Article 4 also outlines the administration of your family wealth trust in the event you become incapacitated. Incapacity or disability means a condition that prevents you from managing your financial affairs. For example, if you have a debilitating illness like Alzheimer's disease or a major stroke, your successor trustee needs to know when it's okay to take over the management of the trust assets. Remember, you can always resign as trustee at any time by simply signing a resignation form. But if you don't voluntarily resign or are unable to, it's here where we describe the circumstances when the torch is passed from one trustee to the next. The trust describes two ways you can be considered legally incapacitated. First, the court can determine you are incapacitated, or two licensed physicians can certify in writing that you are incapable of managing your affairs. If you don't agree with the assessment of your condition by these doctors, you can always petition a court for their final word. Be assured, no one can ever take away your rights to manage assets over your objections without first giving you due process of law. Once a legal incapacity has been established, Article 4 sets forth your instructions on how trust property is to be administered. Upon your incapacity, special provisions have been added to the trust. These allow for planning for your long-term care, to transfer assets into the trust, and to respond to a change in the tax law or a change in a beneficiary's circumstances. One of the most important segments allows your designated representatives to help qualify you for long-term care assistance. These provisions, sometimes known as Medicaid triggers, give your trustee and the agent, under another document in your plan called the Durable Power of Attorney, maximum flexibility in planning for your long-term care. It's important to remember, however, that these Medicaid triggers are not magic bullets that will qualify you for Medicaid or any other government benefits if you are otherwise ineligible. Therefore, we recommend you talk with us about all your planning options if the need arises, and these issues are important to you. Other special provisions in this article allow your representatives to transfer assets to your trust to complete your funding, even though you may be incapacitated and are unable to transfer them yourself. This is extraordinarily important if one of your goals is to avoid probate at your death and to prevent a costly conservatorship or guardianship proceeding. Another critical advantage of your family wealth trust is that you can name someone to represent you and act on your behalf at the bank or other financial institution if, because of illness, you're unable to look after things on your own. In emergency situations, these rights can give you peace of mind, knowing that someone will always be available to help if you are alone and you're unable to act on your own. Let's move on to Article 5. Article 5, Trust Administration at my death. Article 4 governed your family wealth trust while you are alive. Article 5 provides instructions for administration after your death. Remember, there will be no probate, no court hearings, or other government interference for all assets that are actually owned by your family wealth trust. When you die, your successor trustee is authorized to make certain tax elections and to file your final tax returns. Also, the trustee is authorized to pay any claims and expenses that arise because of your death, including funeral expenses, unpaid claims, and the costs of administering the trust. If there were assets that were not transferred to the name of your family wealth trust and had to go through probate, the trustee is instructed to cooperate with your personal representative under the will. Now, this should not be too difficult because the personal representative named in the pour-over will of your plan and the trustee are generally the same people. In any event, these tasks are the normal duties for someone who is looking after the financial affairs of someone who has recently died. Article 6, Specific Distributions of Trust Estate. There are two types of distributions that can happen upon death. One is the distribution of specific assets to specific beneficiaries at the time of death. The second type is a general distribution of the trust estate. Article 6 deals with the specific distributions. We'll discuss the general distributions later. Now, after we complete the general overview of the portfolio, we will go over the choices you made in your personal family wealth trust. Now, at that time, we'll discuss whether you chose to make specific distributions. Article 7, Distributions to Beneficiaries. Earlier, we addressed how specific distributions are made. This article lays out the general distribution of your trust assets after you're gone. At that time, the successor trustee uses the provisions in this article for guidance on how to manage and distribute the remaining trust assets. It has four basic components. First, all of the trust assets available for distribution are divided up into shares for your beneficiaries. Next, if the assets are to remain in trust, the trustees of each trust share assume their positions. Then the administration and distribution of each beneficiary's share is explained, including who will receive the trust share if the beneficiary is not alive at the time of the distribution. Finally, this article describes what will happen to a share set aside for a beneficiary who dies before a distribution. If that deceased beneficiary had children, ordinarily that share would go to his or her children equally. Your family wealth trust was designed to be very flexible and may provide for several different methods of distribution. The trust can make total outright distributions to beneficiaries. It can stagger the distributions over several years. It can make distributions only if certain conditions are met, or it may hold back the distributions and continue to hold the shares in trust. Continuing to hold a share in trust has some powerful advantages. It can potentially provide both divorce protection and lawsuit and creditor protection for your heirs. If you wanted divorce protection for your beneficiaries, your trust may have a component called the Family Access Trust. If you wanted maximum lawsuit and creditor protection for your beneficiaries, your trust may have a component called a Family Sentry Trust. If you have a disabled beneficiary, your trust would have a Special Needs component. Later, when we review your personal family wealth trust, we'll go over the distribution choices you made. Article 8, Lack of Designated Beneficiaries. Article 8 explains what happens in the very unlikely event all the beneficiaries named in your trust die before you. This is sometimes called the nuclear explosion provision because everyone mentioned in the trust has passed on. Essentially, there are two options to choose. Option 1 says if everyone is dead, the trustee should distribute all trust assets to your heirs at law. Option 2 directs the trustee to distribute the remaining trust assets to remote beneficiaries that you specifically named in the amounts you designated. Article 9, Trustee Provisions. Article 9 provides an overview of the duties of each trustee, including you. First, it states that if two trustees are serving together, all decisions will have to be unanimous. Depending upon the option you've chosen, if there are more than two trustees serving at any one time, either a majority is needed for trust decisions or all trustees must agree. If there are disputes between the trustees, they can look to the special co-trustee or trust protector for guidance. This article exempts your family wealth trust from mandatory court supervision. Remember, the whole idea of setting up this plan was to avoid the hassle and expense of probate and court supervision. Now, this doesn't mean the court system is not available to help if there's a problem. It will always be on standby if beneficiaries or trustees request help. Let's move on to Article 10, Powers of My Trustee, which outlines the administrative and investment powers of all individual or institutional trustees. This is the charter of powers for all trustees acting under your family wealth trust. The list of powers is exhaustive, but basically, all the document does is grant every power imaginable that will allow the trust to carry out your wishes. Article 11, Other Trust Provisions. The final article of your family wealth trust sets forth various definitions and general provisions of your trust. It ends with a place for your signature, both as the trustor who created the trust and as the initial trustee who is responsible for managing the trust assets. Your signature is then notarized by a notary public licensed by the state to acknowledge that your signature is valid and that you really are the person who signed this document. Now that's it for the general overview of a family wealth trust. See? That wasn't so bad, was it? Let's move on for a quick overview of the other important documents in your Legacy Wealth Planning Portfolio Binder. The first tab of the portfolio after your family wealth trust is called Trust Property. This is where you can keep an inventory of all the assets owned in the name of your trust. Remember, title to most of your assets should ultimately get transferred to your family wealth trust, so they are officially owned and protected by the terms of the trust. If you have any questions about what assets should be transferred, let us know and we'll provide guidance. We have provided a schedule that acts like a running inventory of assets owned by your family wealth trust. This schedule will help your family identify assets owned by your trust after you're gone. This asset inventory is not a legal document, but an aid to your family in determining what assets your trust owns at your death. We suggest that every year you review your inventory of assets just to make sure they are up to date. By doing this, you'll save your heirs countless hours of detective work trying to locate the assets in your estate after your death. Behind this schedule, we provided a place for you to store copies of all the actual documents that transfer title from your individual name to the name of the family wealth trust. Your pour-over will is located in the next section, and it is a supplement to your family wealth trust. This document plays an important role in your estate plan. Now remember, the family wealth trust controls the disposition of all the assets that have already been transferred to the trust at the time of death. But what if you forgot about an asset, and at your death it's still in your individual names? Well, put simply, the trust would not have control over those particular items, but your pour-over will would. The primary function of this document is to pour over any assets into your family wealth trust that were not transferred while you were alive. Now, keep in mind that any assets transferred by the will must go through probate, and that goes against one of the major reasons you created the trust. So think of your pour-over will as a kind of safety net. It's best to have all appropriate assets transferred to your trust before you die. But in the event that something is missed, your pour-over will can pick it up and transfer it into the trust. Now, if you look at your pour-over will, you'll see that this document is actually very simple. It merely states some of the statistical information about your family and names the people you've chosen to act as your personal representatives. If you have minor children, the pour-over will names your choices for guardians to care for them until they reach the age of majority. Under the terms of your will, a personal representative, sometimes known as an executor, has many of the same functions as the trustee under your family wealth trust. In fact, the trustees and the personal representatives are often the same people. Because of the nature of this document, the only beneficiary of your pour-over will is typically your family wealth trust. The next tab of your portfolio has a wealth of information on funding your family wealth trust. As we discussed earlier, funding means transferring the title to assets into the name of your trust. This section of your portfolio contains instructions on how to transfer some of the most common assets. The next tab contains the certificate of trust. This is a summary copy of portions of your family wealth trust. It should be used whenever anyone wants to see a copy of your trust document. But you don't want to reveal all the details of the trust and the assets it holds. For example, your real estate agent or stockbroker may ask you for a copy of the document when you buy a new asset in the name of your family wealth trust. Now, this is a perfectly reasonable request. After all, they want to be sure that there really is a family wealth trust and that you are the person authorized to do business on behalf of the trust. They don't, however, need to see what assets you own or who will inherit those assets after your death. Quite frankly, that information is none of their business. The next tab in your portfolio is called life insurance. It provides a place for you to list all of your life insurance and annuity benefits. And for practical reasons, this is extremely important. You may have thousands of dollars of life insurance, annuities, or other death benefits, and no one other than you knows anything about them. And clearly, your heirs cannot make a claim for benefits they know nothing about. Using this summary section, you can list all your life insurance and annuity policies, as well as pension benefits and any U.S. government benefits. The next tab of your portfolio is also designed to help your family find things after you're gone. It's called Location Lists, and it essentially tells your family where to find all your estate planning and valuable business papers. In addition, you can record the names, addresses, and telephone numbers of all your family members and important advisors. Just think about it. If you died tomorrow, would your family know the name of your accountant, your banker, or your doctor? By keeping this information updated, you can save your family time and money in winding up your affairs after you're gone. The next tab contains your property power of attorney. This important estate planning document allows you to name agents to manage your property for you if you are legally incapacitated and unable to make those decisions on your own. Now, it's important to remember that the assets transferred to your family wealth trust will be managed by your named trustees. But what about assets you forgot to put into the trust? We know that the pour-over will looks after these assets at your death. But who will manage them if you're alive and incapacitated? The agents you've named under this property power of attorney will control those non-trust assets either immediately or in the event of your incapacity. This prevents a costly and time-consuming court conservatorship or guardianship proceeding. The next tab is for your healthcare documents. They address important matters that have nothing to do with property or finances. They provide your instructions on what healthcare decisions should be made on your behalf if you're unable to make them. The Advanced Healthcare Directive, also known as the Durable Power of Attorney for Healthcare or Healthcare Proxy, appoints the persons you want to make these healthcare decisions for you. The HIPAA authorization form allows the people you authorize to get your healthcare information from your doctor or other healthcare professionals. This is extraordinarily important these days because doctors and hospitals will not disclose healthcare information to others unless one of these authorization forms is produced. The next tab in your portfolio is for storing other important documents. Here we suggest you place either originals or copies of essential documents if room permits. Here's a sample list of documents that may be helpful to your heirs once you're gone. Birth certificates, baptismal certificates, marriage licenses, divorce judgments, death certificates, certificates of naturalization, certificates of permanent residence, passports, and of course, driver's licenses. The next tab of your portfolio is the Death or Disability section. This section provides invaluable information to your agents under your powers of attorney as well as your successor trustees. It contains helpful checklists and memoranda that can be reviewed in the event of your disability or death. Despite all this helpful information, it's not a substitute for qualified legal advice. Remind your heirs or responsible parties to contact our office immediately if there is a death or disability. Our firm provides a no-cost consultation to your agents and successor trustees to make sure they understand how to properly carry out their duties. The final tab in your portfolio contains your estate planning letter and your legacy workbook. Let's first review your estate planning letter and why we've included it as a part of your plan. The purpose of the estate planning letter is very simple. It's the place where you can give informal instructions to your family about the distribution of miscellaneous items of personal property, your burial or funeral wishes, and other important but non-legal messages. For example, you may have small, relatively inexpensive items of personal property that you wish to give to one of your children or friends. Although these items may not have high material value, they may be rich in sentimental value. But you may not want to clutter up your family wealth trust or your will with descriptions of all these little items that may change from time to time. This estate planning letter fills that need by giving you an informal place to list all those little gifts. On Exhibit A of the estate planning letter, you can write down the description of the item and the name of the intended beneficiary. There's no need for formal witnessing or legal procedures, just a simple declaration of your wishes. In fact, if you like, you can list every little item you wish to distribute to help prevent any arguments or hurt feelings after your death. This is extremely important because we found that most family fights happen over these sentimental items like grandma's pie plate or a favorite vase. Make sure the entire family understands where these items are going so you can mediate the decision while you're still alive and competent. Of course, this disposition of miscellaneous items is not intended to be a substitute for your family wealth trust or your pour-over will. And if there is a conflict between this letter and your more formal estate planning documents, your formal documents will always prevail. Experience shows that beneficiaries rarely contest the gifts of personal items when the decedent's wishes are clearly stated. However, family fights do arise, especially when there is no mention of a particular item. And for personal sentimental reasons, a father's old wristwatch may be the most important gift of the entire estate to a loving son. In the same way, a well-worn simple wedding band belonging to mother may be priceless in the hands of a daughter or a grandchild. Taking the time to jot these little items on your estate planning letter can assure these heirlooms go where you want them to go. And if you are concerned about someone altering the list, just put your initials next to each item. Exhibit B of your estate planning letter is where you can describe your burial and funeral arrangements. If you don't give your family any instructions, they'll be left guessing at what your wishes might have been, and decisions will have to be made when the family is least able to make rational or sensible choices. Finally, under the heading Other Directions to My Family on page 2 of your estate planning letter, there's a place for you to insert personal messages to your family. These instructions can include any words of wisdom you may wish to pass on. You may want to share some of your family's wisdom with your children or friends. Who knows? It may be the most valuable asset in your estate. Your My Legacy workbook allows you to tell your life story in your own words. There are pages for the husband and for the wife that allow you to preserve your memories and family history. It's very important that you not just pass on your wealth to your children, but also your values, beliefs, and life experiences. The booklet is an excellent way to get started with your legacy planning. That's it. We're finished reviewing the sections of your legacy wealth planning portfolio. At this time, we're going to continue on and review the specific choices you made in your planning documents. I'm now going to hand it back over to others on your law firm team to review the specific choices you made in your planning documents.
Along with the general terms of your legacy wealth planning portfolio, create a comprehensive estate plan that should serve and protect your family for years to come and give you the peace of mind you deserve.
Well, by now, you should have an appreciation of how comprehensive your estate plan is. Your portfolio will be available for you and your family to review for years to come. The presence of these estate planning documents should provide you with peace of mind, knowing that your loved ones are protected. As we come to the close of our video tour through your legacy wealth planning portfolio, we want to offer you our sincere appreciation for allowing us to prepare these important estate planning documents just for you. Although your documents are being signed and finalized today, we don't consider this the end of our relationship. We view it as a beginning of a long collaboration and plan to stay in touch with you and your family as the milestones in your life triggers certain parts of your plan. Be assured, our firm will always be available for consultation and guidance at any time you need us. Thank you so much for your confidence and trust in the Collins Law Group.